One common type of evidence that can be damaging to the plaintiff's case, to the employee's case in an employment case, whether it's a trial or in arbitration, is any type of nasty or rude email or a text message or any other type of writing created by the plaintiff that makes him look rude and makes him look like an unlikable person. And employers love to use this type of evidence at trial, especially in front of a jury. Anything they can put in front of the jury that would make them dislike the employee would be helpful to them, because if a jury or if an arbitrator doesn't like the employee, they won't trust him, they won't believe what he says, and as a result the employer will more likely win the case and the employee will more likely lose the case. And even if the employee wins the case, he might not get as much as he otherwise would. So how do you deal with that type of evidence? How do you deal with those emotionally charged emails or text messages that you may have sent a while before your termination? And how do you deal with the emails, the text messages that may make you look bad, but they don't have direct relevance to your termination? In other words, you were not terminated for sending those text messages and emails. Well, the single best way to handle that type of evidence is to acknowledge that you made a mistake and to apologize. You can apologize in front of the arbitrator or in court. You could say, I'm sorry for sending those emails. I shouldn't have. I was emotional. I was angry. In hindsight, I shouldn't have done that. I should have sat on it and I should have read my email and I shouldn't have said those things. Or maybe I didn't mean to say those things. I was just angry. It is much better than trying to justify why your boss deserved all these bad words. Because remember, you and your boss are not equal. You're not equal at work, and ironically, you're not equal in court. The jury, the judge, the arbitrator, they know that just because it's fair to say something mean and nasty to your boss doesn't mean that you should be doing that or that you should not be punished for doing that. So any type of emails, any type of text messages that make you look bad, that make you look like someone angry, like someone who likes to get in your management's face, you should acknowledge that you made a mistake and you should apologize. That's the best way, the most mature and the most quote-unquote likable way to address that type of evidence. Now think about it. How often do arbitrators, judges, and juries hear an employee apologize for sending something to the people that he is suing? Almost never. So the moment they hear this from you, it will make you come across as a more likable person and someone who is mature, somebody who is able to take responsibility for the things that he's done wrongly while he was employed by the employer defendant, and not someone who thinks that he can do no wrong. Someone who accepts responsibility naturally is a more likable person, is a more likable plaintiff. So this is a simple and effective way of how you can take bad evidence, turn it around, and use it to your advantage at trial or at arbitration. Thank you.